Welcome to Brad Dacus Live. I'm Brad Dacus, president of the Pacific Justice Institute. And folks, we've got some really good news today from the Supreme Court. We're going to talk about that later on in this show. But first, I want to address something that I think is very important. It's another case from the United States Supreme Court. And this case is dealing with the pro-life issue, and it's directly addressing a law from the state of Louisiana that was actually enacted to protect women from certain consequences, certain things that may come up so that they could be able to go to a hospital for emergency care, because sometimes abortions do end tragically. Sometimes women die from abortions, or they need special medical care to prevent them from dying. So this is a law that was passed to protect women, and yet the Supreme Court ruled that it was unconstitutional. To talk with us about this and other cases here on Brad Dacus Live, we have with us Michael Peffer. Michael Peffer is the director and attorney of the Southern California office for the Pacific Justice Institute. Michael, welcome to the show.
It's always great to be here.
Yeah. Now, this case, I'll be honest with you, I was very disappointed.
Yeah.
Because I thought it would turn out differently.
Yeah.
You know, the Justice Roberts, who had the deciding opinion of 5-4, very narrow decision.
Yes.
He, as it turns out, actually decided differently on almost the same set of facts from the state of Texas.
Yes.
And yet he switched when it came to this case. Let's first talk about this case. What exactly did it say? It was almost identical to the Texas decision.
Yes.
What exactly did it say?
So the Texas case was and this case were both laws by the state, Louisiana and Texas. They were both laws that said, hey, you have to have a doctor has to have admitting privileges at a hospital no further than 30 miles away from an abortion clinic. So in other words, in order to account for an emergency, the doctor has to have admitting privileges at a hospital so that if tragedy happens, we of course believe that tragedy happens no matter what, because an abortion occurs.
Yes.
But if a woman's life becomes in danger or something happens, the state wanted them to be protected.
Yeah, it's very logical, very rational.
Absolutely.
But the other side in the matter, the abortion clinic people, they were very much opposing this. And their argument, I understand, was that, okay, in Louisiana there's 3 abortion clinics. This will reduce it down to 1 or 2.
Right.
Right now they say there were, I guess, 5 abortion surgeons that would go in and kill the unborn.
Yes.
Frankly, I'm surprised there even should be that many who have that kind of a shallow conscience to do it. But okay, but there were 5 in Louisiana, and reportedly this would reduce it down to 1 or maybe 2. But there would still be the ability for abortions to occur.
Right.
Yeah, I think that it was actually very weak, because I don't think that they were really able to show that women would not be able to have an abortion or find a place to have an abortion, even out of state for that matter, nearby in Texas or other places. But it seemed like that was all they needed to show to satisfy the majority in this case.
You know, it's interesting. It's almost as if they say, hey, it's okay if a woman gets hurt as long as she can get an abortion. That's really what this is saying, because these kinds of laws that ensure that the doctors have admitting privileges, there's other subjects upon which they have to have admitting privileges as well. And the interesting thing about this particular case is that 3 out of the 5 clinics, before this case was actually decided, they have been fined and closed. And so these were troubled facilities. And I don't know how we got to this point, Brad, where we're saying, hey, if the woman's ability to get an abortion is so important that we don't care if the doctors are quality or not.
Yeah. And that's really what they're saying. They're saying they're so obsessed with pushing the abortion, pushing killing the unborn baby, and the money interest and the lobby interest is huge. Planned Parenthood, the abortion mill industry, makes untold large amounts of money,
Yes.
the hundreds of millions of dollars. So they've got this heavy lobbying, heavy financial interest. They want to make the money. They want to kill the unborn because they make money off it, selling body
Yes.
parts. I get that. I understand that. I'm just disappointed that the court would not understand the compelling state interest of protecting and providing basic minimal standards for health care for women when emergencies do happen.
Right.
No one wants to see a woman, whether they're pro-life or pro-abortion, die from an abortion procedure. No one wants to see them lose their life. And yet the Supreme Court in this decision said, you know what, the interests of promoting abortion and making it more convenient to kill the
Yes.
unborn. Really, that's what it's about,
Yeah,
conveniency.
yeah.
It's not that they couldn't have an abortion,
Right.
about convenience. That's going to trump the ability for states to be able to engage in the practice of protecting them from medical harm, which they, once again, I think you point out very well. This isn't an unusual requirement to have a clinic over here where the physicians have to be licensed and accepted in a hospital in case there's medical emergency.
Yeah.
That exists all the time.
Indeed.
But they're saying, oh, no, but we're dealing with abortions here. No, we don't want that because we don't want to do anything that in any way make it more uncomfortable and for fewer women to possibly not have an abortion.
Absolutely.
We want to kill as many unborn babies as possible. That really, I think, is the messaging here when you look at the facts logically. And I was just so disappointed with Roberts.
Right.
Here, the Texas decision, he was on the dissent. Okay,
Yes.
he was on the dissent. It was 5-4. We had some changes in the Supreme Court since then, but 5-4, and he was on the dissent, and he said, he says, states have a right to protect. I mean, he argued the minority opinion.
Exactly.
And then in this decision, he switches.
Right.
And he claims stare decisis. Explain stare decisis to people to try to understand possibly where he's coming from. I know the people like Thomas was not very happy. Kavanaugh was not happy. Neil Gorsuch and Alito were not happy.
Yes.
But he claimed stare decisis. Explain that, please.
Well, so many folks, good commentators, are very disappointed with Chief Justice Roberts. And here, this was such a sort of a bizarre take. So he basically said, Roberts, even though I disagreed with this Texas case, it's called Whole Women's Health, even though I disagreed with that holding that allowed the Supreme Court to stop these kinds of laws that require admitting privileges, even though I disagreed with that case, I have to follow this case, because of stare decisis, which what it really is dealing with, without getting into technically, is dealing with precedent. It says basically that in order for in common law, you have to have some system of precedents where opinions that are decided by the Supreme Court, especially, but other cases, other courts as well, opinions that are decided by the Supreme Court must be followed, and indeed, in some cases, even by the Supreme Court itself. And I say in some cases because, as you know, they don't have to follow a precedent or a stare decisis all the time.
Yeah, and there's actually some good reason for them not to. For example, we had Plessy versus Ferguson.
That's right.
Saying separate but equal. It's okay to have blacks in one part of the train, one car for the train, and then whites in a different car of the train. And that was case law.
Yes.
And the Supreme Court looked at that and said, years later, said, this is unconstitutional. It violates the Equal Protection Clause. Brown versus Board of Education. Let's set the matter straight. And I think that in the same way, I'm really surprised that he would lay claim to stare decisis because this is dealing with fundamental civil rights here.
That's right.
It was a narrow decision before. It was 5-4 before. It was a narrow decision. It wasn't like a 9-0 or 8-1 or 7-2 even.
Right.
And then third, we're talking about people acting and relying on it. There's no ongoing reliance. It's not like abortion takes a 10-year commitment. No, there's not like massive changes taking place in terms of commitment. So I think that the basic rules of stare decisis and being able to reverse the prior decision are there, and that stare decisis should not have been laid claim to, especially when you have a justice sitting on the bench, Justice Roberts, who in the earlier case, almost identical,
Yes.
comes out and says, this is the right of a state to have this kind of a statute to provide greater medical protection for women who are having abortions, even if there may be some more inconvenience for having abortions. And then he flips over here.
Right.
And so I think that was incorrect. Also, the one problem I have with stare decisis, especially with a 5-4 decision, it ignores the element of the voice of the people through court appointments.
Yes.
You know, when we have one of the main reason people voted for President Donald Trump in 2016, the number one reason was because of court appointments. People said, we are tired of judicial activists. We want a Supreme Court that's going to defend religious freedom, a Supreme Court that's going to respect the rights of the states to protect the unborn.
Right.
We want religious freedom protected, parental rights. I mean, this was the thrust. That's why Trump was elected. He appointed justices, meeting those criteria. And so when we allow stare decisis to be so loosely thrust upon us, it actually in a way ignores the ability for we the people to have our voices heard through judicial appointments.
And listen, as a whole, all lawyers can understand why stare decisis needs to be there. But as you pointed out, some very, very important cases were decided wrongly and later overturned. I was thinking also of Dred Scott, where the Supreme Court actually ruled that black people are less of a person than white people. And thank God, later Supreme Courts came in. They weren't worried about the stare decisis. They held that decision ought to be overruled because it was incorrectly decided. Right. Here, Roberts had every chance to say, hey, this case was incorrectly decided in the beginning. I even dissented on it, and so I'm not going to join the majority here.
Right.
And so that's crazy. It
is crazy. He is seemingly sort of wanting to sort of be a pleaser. Sort of like, I sort of want to be in the middle. I just sort of want to get along. Can't we all get along?
Yeah.
I want everyone to, want to be right there in the sweet spot. And that's really unfortunate because it's really not a Chief Justice's job to be a person pleaser.
That's right.
And instead, it's like Justice Rehnquist. It's to maintain the integrity of the bench and rule as you see it, as far as the Constitution.
Yes.
Not as you want to please it, but as you see it.
Yeah.
And I think that's a very disheartening and discouraging in that regard. But we definitely have a very positive decision we're going to talk about in the second part of the show, a victory for religious freedom, which I think people are going to be very encouraged about as we move on. But before we get to that part of the program, though, I'd like to talk about a very important appeals court decision that came out of Wisconsin dealing with voting restrictions. Now, people may look at this and say, okay, voting restrictions, how boring.
Yeah.
It's not boring because what we're talking about is the attempt to force states to compromise procedures protecting the integrity of the process for the hopes of getting more people to vote, potentially illegally, unlawful voting, so they can push to get their person elected. I'm trying not to be partisan here. It's tough, but it's real. There's one party that is known for wanting to loosen the restrictions, make it easier for fraudulent voting to take place on a massive scale.
That's right.
It's not even something we have to even, conjecture about. I mean, it's very proven that's what they're trying to do over and over again. Well, Wisconsin was no exception. Talk about this case. What exactly are we talking about in terms of restrictions? And are these restrictions that were established there by the people, by the legislature, why are these restrictions really unreasonable? Are they justified? And I think that's what the court looked at. Let's talk about those restrictions.
Right, exactly. And before we move on away from the June medical case, I wanted to say there is reason to hope because Justice Thomas, he all but said he's ready to overrule Roe v. Wade. So there's reason for hope there. And I just
Yes.
we need to keep praying for these justices. But Justice Thomas was strong here and said that the states have the authority to do this. And so I just wanted to say before we moved on that, yes, this is an incredible.
Well, and it is another reminder of
Yes,
how
right.
important it is for us to vote, because whoever's in the White House, whoever's dominating the U.S. Senate, they are the ones who are going to decide the next Supreme Court justices,
That's right.
and whether or not we're going to have the ability for states to pass laws protecting the unborn
Yeah.
and stopping the massive genocide, the massive murder of, I think it was about 900,000?
Yes.
900,000 unborn babies every year, folks,
Yeah.
are killed, are murdered,
That's right.
and on a massive scale. And it's actually very racist as well.
Yes.
We're talking about 1 in 4, I believe, are African American. Abortion clinics are targeting African American communities. That's who they want to kill. Even Margaret Sanders, the founder of it, her whole desire was to limit the black population.
Yes.
That was her stated goal from the beginning. That was Planned Parenthood's objective.
Yeah.
So I think it's very important. There is hope. We need to vote. Now, we have some great news. And I've been saving the best for last.
That's right.
This is a decision that came down from the United States Supreme Court. It's a 5-4 decision. They'll have a major impact on religious freedom, which, as people know, that's our heart, that's our passion, is defending religious freedom for everyone throughout the United States. The case is Espinoza versus Montana Department of Revenue. And as I understand it, it involves the ability for individuals, for parents, to be able to have their children in a private Christian school and not be discriminated against
Yes.
by a state that is allowing the money to go to secular private schools. Tell me more.
Yes, and this is a very important decision. We saw hints of this earlier this year, or last year rather, in what is known as the Trinity Lutheran case. It involves public benefits that a state offers, and oftentimes they offer this public benefit and they say churches need not apply.
Or religious schools.
Exactly.
Need not apply. Because
Exactly.
your religious separation of church and state, or we have in our state constitution something like the Blaine Amendment,
Yes.
which basically says the same thing. It's that government can't financially benefit anything that's religious. They can
right.
discriminate against religious institutions.
Right.
We've had a real problem with that, obviously, because it's government bigotry and discrimination. As government
is.
grows more and more, then it makes it more and more difficult for institutions of faith to survive on an equal playing field. And I don't see government shrinking. It's only expanding more and more. So this is becoming a greater and greater threat for religious schools, institutions, ministries to be able to survive when government's giving money to secular institutions, non-Christian institutions, and withholding it from others. That's an unequal playing field.
Yeah.
This decision basically, as I understand, said that that was unconstitutional. What are the facts about this case so people understand that just quickly the progression?
So Montana did this law, and we think that these are great laws when they say, hey, if you're a citizen who sends your kids to private schools, then you should be able to get tax credits when everybody else can get a tax credit for their schools.
Right.
And so, I mean, this is the whole school choice issue that we are great advocates for, because it could be a life-changing thing for many in this country, particularly in the inner city, where the schools turn out to be terrible, and so that they could, in this case, they said, hey, you can pick your school, and we'll give you a tax credit for it. But because their constitutional had the Blaine Amendment, as you say, the no aid clause, that is, you can't aid any religious institution, then they said, well, these folks couldn't get one for this Stillwater Christian School, these 3 mothers.
Yeah, so they decided to treat them differently.
Yes.
And the lower court said you can't do that.
Yeah.
And on appeal, like, they prevailed. But then the state Supreme Court said, oh no, you can't do this because this benefits religion.
Right.
And then the state of Montana said, okay, we're going to end all
Exactly.
future funding for any private schools at all. Since since there's a possibility we can't discriminate against those religious people or institutions, we're going to play it safe. We're going to just say, okay, this is no longer an issue. No private schools will be able to benefit secular religious, since we might be able to not just, because we're so adamant against discriminating against those religious schools, we're going to play it safe and say no private schools.
That's right.
So in fact, some people thought the Supreme Court might say, well, it's moot. They're not supporting any private schools now, so it's moot, so we'll just not even decide it. That was a real concern.
Yes.
But no, they decided to go ahead and rule on the issue here, even though that Montana had pulled back completely. And I'm glad they did, because otherwise this would be up in the air. And it was a 5-4 decision. And Justice Roberts was the one who, we talked about him earlier.
That's right.
He actually ruled favorably towards religious freedom here.
That's right. He did, and he authored this opinion. And so, thankfully, Roberts does have some bearing here still, and we're very grateful for that. And here, there had been a case, you remember a Trinity Lutheran case, where in that case, the state decided to give aid for when there was a building project or of private schools, and they said, well, anyone can get this except for religious schools, and in that case it was things to make playgrounds safer, which, of course, you want playgrounds safer. When that's an issue.
So those religious kids or in a religious playground, they're just as important to keep from having a concussion.
Absolutely.
As kids in secular playgrounds,
Yes.
secular private schools.
Yes.
Yeah, I think that was it was a great set of facts to set that case law.
Yeah, it is.
So then that was decided, dealing with playgrounds.
Right.
Looked like that was a good precedent to build on. Then this case came down, and in this case is actually building on that basic predicate. And basically what the court held, I think this is real succinct, he said, a state need not subsidize private education. So he's saying, hey, states, if you don't want to subsidize private education, you don't want vouchers, you don't want tax credits, you want to just have only government schools,
right,
and not have choice, particularly for people in the inner city who need choice the most.
Yeah.
That's fine. You can do that. You politicians can pass those. They can do that. He says, but once a state decides to do so, that is, subsidize private education, it cannot disqualify some private schools solely because they are religious.
That's right.
Very, very succinct, very to the point. What do you think this decision is going to have? We already see now states across the country, it's really clear. You're going to have private schools that are non-religious. You've got to have the same equal footing of helping religious private schools. As a matter of policy, I think it's a fantastic area for states to take, to move on. I know red states with Republican governors, Republican legislatures, they're doing that.
Yes.
I think we have, it was 17 plus states, maybe more now, that have either a voucher or tax credit system, which is very helpful to people in the inner cities.
Yes.
And to be able to have that choice where public schools have failed so much. In fact, I'm going to make a little side note here. We talk about discrimination, we talk about systemic discrimination and things like that.
Yes.
The number one bullseye of causing unequal treatment or benefits in the United States today, the greatest discriminatory, most bigoted institution is government schools.
Yeah, absolutely.
People in suburbia have a much higher education in those government schools than those in the inner cities. And yet it's those governments in the inner cities and states dominating with Democrats,
Yes.
who are saying, no, we want to keep them down. We want to keep them poor. We don't want to give them equal opportunity. We're going to make sure we're going to give into the demands of the teachers union so we can keep these people poor and voting for us and our Democrat liberal agenda.
Yeah.
And yet when we had on the ballot in California, school voucher initiative, of the different demographic groups, it was interesting. The demographic group that voted the most, the highest percentage by far, for supporting vouchers in school choice was in the African American community.
Yes.
They know that they need it, and unless our politicians are changed in some of these blue states, and these legislators and governors are changed, their rights to have any hope of having a quality education through vouchers and be able to go to private schools of their choice
Absolutely.
is going to continue to be hindered. Also in California, I understand there's legislation pending that's going to greatly limit charter schools
Right.
and the ability for new students to be able to enroll at all in charter schools, which is once again a big punch in the mouth towards people in the inner city wanting to have any kind of hope for alternative education. So this decision, getting back on this case, is a great decision. States that want to, like red states, that want to provide support for private education, it's there, it's protected, it's very solid. As far as moving forward, this can actually have some great implications on getting rid of some of these discriminatory Blaine amendments that allows states to justify discriminating against religious institutions.
That's right.
What else could it possibly do moving forward?
Well, we're certainly hoping, and you raised the excellent point, inner city schools. In fact, it was Malcolm X, who I don't quote very often. He said it's a vicious circle because they go to poor schools in the inner city and then they don't get good jobs. And so we need to deal with education. So for that sake, that's a huge deal. This needs to continue. And people need to speak up for school choice. And so we're hoping that this kind of case, perhaps we can move towards a place when the Blaine amendments are found to be unconstitutional.
Throughout the United States.
Exactly.
Very important.
Yes.
Very important. I think this is very encouraging, and I'm very hopeful that we're going to continue to see positive results coming from this pro-religious freedom decision.
Yes.
Ideally, once again, I mean, it'd be great to have a 9-0 decision on this. It wasn't. Only 5-4. 4 of those justices thought it was totally fine for government to be bigoted and discriminatory towards a private school simply because of their faith, simply because they're a religious institution.
Yes.
That's disturbing. We actually have those 4 believing entitlement for religious bigotry and discrimination still sitting on the United States Supreme Court, and that's not going to change for the better unless we have appointments, and those appointments, future appointments, are going to come from someone sitting in the White House and sitting in the U.S. Senate making those decisions. Once again, another important decision, folks, of the need for you to vote and for you to get involved in your community. And now's not the time for us to wimp out or to be just complacent. Now's the time for us to vote. It's that tight, 5-4 decision. We saw it go for supporting convenience in baby killing, unborn baby killing through promoting abortions, and on this same week, then we've seen a switch 5-4 for religious freedom. That's how tenuous. That's how fragile the court is right now, and why we need to get involved and make a difference. So vote this coming election. I think that's a definite lesson. So folks, there you have it. It's our God-given freedoms we're talking about. Now, let's choose to keep them. I'm Brad Dacus, president of the Pacific Justice Institute. Let's continue the fight for your freedoms.